question to ask. So I am in the process of going to trial for my juris dispo, and all sides, including my attorney, my husband's attorney, are saying that they're going to, the judge is going to order me into drug court. And I was wondering, part of their proposed sentencing that CPS has written out for the judge, part of that is saying that we have to sign over our HIPAA rights to CPS. In other words, if we do any kind of psychological anything, we have to sign releases to CPS. And I was wondering, is that legal?
You know, that's a very good question.
Hello?
Can you hear me?
Yes, I can.
Okay. So that's a very, very good question, because it comes to the crossroads of federal law and juvenile court state law. And I'm seeing a lot more cases, or maybe it's because I'm seeing a lot more issues, I'm just a little bit more experienced and educated, where sometimes these laws or these orders in juvenile court infringe on very important medical rights and HIPAA rights. Now, the answer to your question is it legal? Maybe. And I can't give you a definite answer because I'm not sure that it has been decided by our courts as to whether it's legal or not legal. And sometimes if it's decided by a court that it's not legal, it may be later overturned by a higher court that it is legal, and then overturned again by another higher court that it isn't legal. So, you know, it's a very gray area. I can tell you this, because you have important federal rights under HIPAA, you do not have to sign, in my opinion, you do not have to sign them away. Now, that's just my opinion, and that's something that you and your attorney are going to have to decide depending on what type of order the judge makes in the juvenile court. However, and this is a big however, if you don't comply with the juvenile court's order and you don't get it overturned on appeal, or someone else doesn't get it overturned on appeal throughout the country, you're not going to get your children back, because you didn't theoretically comply with the judge's order. Now, here's something very interesting. Just yesterday, I was in Santa Clara County in the city of San Jose on a case where the department, in my opinion, can't prove the case unless they do have my client's medical records, which they have some of them, and I'm not sure how they got some of them, but they don't have all of her medical records. And they're going to try to prove a case without her medical records. Yesterday, I kind of got pushed from all sides, minors council, county council, and the court to, release that information to the county. And I've been consulting with another very experienced juvenile attorney in town. His name is Art Lasalento. And I think that we're going to be filing a writ to the Court of Appeals in that particular district, because I don't think the court can make me turn over her private medical records. So we're going to have some type of dispositive issue hopefully coming up soon. If the Court of Appeals decides not to rule on the case or rules against us, we still can bring it up on appeal if we do lose this trial eventually. And the trial starts later on this month. But anyway, so you've asked a very good question. But for your purposes, I would say, as the state of the law stands right now, if you don't sign that HIPAA release, you may not be able to reunify with your children. Now, I'm not saying you won't be able to, but the odds would, in my opinion, would be going against you at this point under the state of the law in California right now. I'm sorry I can't give you a more definite answer. Go ahead.
No, you're giving me money. I have another question. Speaking of appeal, we already know that we're going to have to appeal our case. We know that. My husband was doing some research about what do we need to do with our attorneys to protect our right to appeal. In other words, if they don't object to certain things or say certain things, then we can't appeal, correct?
Well, yes and no again. If they don't object to certain things, the Court of Appeal may consider that a waiver of, your appellate rights on that issue. Or you could always argue what they call ineffective assistance of counsel. So in these types of cases, like in criminal cases,
Like the Marsden.
No, not Marsden.
Marsden motion.
Okay. So I was trying to answer your question, and you are mixing up a couple of different issues. In your mind, it may lead to the same thing, but you got to keep these issues separate legally if you have going to have any chance on appeal. Okay? And the issues that you're mixing up are the Marsden hearing. And for the audience, a Marsden hearing is allowed where you have a conflict with your attorney. You can ask for the courtroom to be cleared and ask for a Marsden hearing where just you, the judge, the court reporter, and the bailiff are present, and the clerk. And you tell the judge why you need a new attorney because of some conflict of interest. What you had originally asked me was the ineffective assistance of counsel argument, which falls under a completely different statute or actually constitutional issue. And that's where you have been represented at trial, and the counsel didn't do a good job or an effective job. And then on appeal, you can raise that to the Court of Appeals that you had ineffective assistance of counsel. Marsden.
Do I have to say anything at trial to ensure that, or is it something that automatically will happen when I file for the appellate court?
I think both. But the problem is since you're represented by an attorney.
She's court appointed, of course. She's a public defender. She waits until 5 minutes before the whatever, and she's refused to ask questions I want her to ask. Things that are pertinent to my case. She refuses it.
When you had the Marsden hearing.
And I did ask for Marsden.
Did you get a Marsden hearing?
I have not had a Marsden hearing. No, sir. I asked for it. Like I said, the judge said, we'll talk about that next week. We're not going to talk about that now. And then next week came, he was on vacation, so he is all purposes. So even though there was a judge there, they would not allow him to hear anything we had to say. He just rescheduled it for the 14th, which is Thursday. And I'm having business with my kids, and they're telling me they want to come home. And my attorney will return my phone or my email.
If you put that in writing,
Yes.
okay, and you file that, and you have your declaration under penalty of perjury, I would guess that the judge is going to be forced to make a decision.
When you say file that, where do I go to file that? Just to the clerks? At the courthouse, or where do I?
Yeah, when you find the template, and I'm thinking that it will also give you instructions on how to file and serve, but you would file that at the clerk's courthouse. You would definitely give a copy to your attorney.
I just have 10 questions to ask counsel on the record to both social workers. First of all, to my daughter, who will be testifying, to my husband, and to one of my witnesses. 10 questions. Is it possible for the judge to let her stay on my case and let me ask those 10 questions?
My answer is yes, that is a possibility. And I have seen that happen in other cases. Cases that I wasn't involved in, but I was sitting in the courtroom and I saw things like that or similar things happen.
Well, I sure wish you were a court-appointed attorney now, San Joaquin, because I sure could use you. Thank you so much.
All right.
Yeah, let's see what happens. I need to do this before the 14th Thursday, correct? So
I would do it.
I
I would go.
head down to the law library.
Yeah, I would go to the law library today. Try to prepare what you need to prepare tomorrow, and then file it on Monday.
I will do just that. And
Okay.
I thank you so much for all your help so far. Keep